Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney at the R&R Law Group located in the always beautiful and sunny Scottsdale, Arizona. And today, my friends, we are talking about, as soon as I can get this cord out of the way, get out of here, move, come on out of here. All right, I got to press these buttons over here. And today on the show, we're talking about the maximum. That's right, the maximum is the word of the day. Why? Because we've got several attempts in several different arenas where there is a lot of activity. We're talking about the prosecution of Donald Trump. Of course, this is taking place on the back of the raid that happened at his residence in Mar-a-Lago. And we just last week learned that the Supreme Court had something to say about this. They sent it back down from the Supreme Court to the 11th Circuit Court. And the DOJ now is trying to really drive this thing home, get maximum effect out of this. And that involves getting rid of the special master. They're trying to ask the 11th Circuit, now that they've won at the Supreme Court, to give them even a bigger victory. Means remove the special master, remove the referee, and allow the DOJ to run roughshod over everything. So we're going to go through that. It's a pretty hefty brief. You can imagine it's in the 11th Circuit, so I believe it's about 60-something pages. We'll do our best to get through it and leave out some of the heavy lifting, but we'll also take a look at the actual order that came out from the Supreme Court, as well as the docket from the 11th Circuit. So a little bit of heavy lifting in that first Trump segment, but always well worth it because we have some big developments. And then we've got some interesting news on a Trump-related story. Of course, this is Steve Bannon. Big headlines today. We've got two pretty major documents, actually, to attend to. One is the DOJ's sentencing memorandum, where the U.S. government is asking for 6 months in prison and $200,000 in fines. And they put together about a 20-something page document where they explain why Bannon deserves it. The maximum under the statutory maximums, they're saying he deserves every bit of it. So we'll read through their justification for it. Before we jump into Steve Bannon's defense lawyers, they submitted their response to that. So the prosecution's asking for the max. We have the defense is asking for the minimum. And we'll read both sides of that from both sides of the aisle. So that will be a little bit more heavy lifting. We've got some serious legal maneuvering to unpack here today. Before we take a look at the most recent bad news for the Biden administration, and really for all of us, this is the 100% chance that we're going to be in a recession. And, this is not me saying it. It's not, a Republican saying it. It's Bloomberg. Bloomberg came out and they said, well, look, we've been doing a lot of modeling on this recession stuff. And, Bloomberg, they've got a lot of data, terminals and all sorts of materials. And they sort of, they charge you big money for this material. Well, they do models and they said 100% chance of recession if we're not already in one or whatever number is. So it's not good. And the media was really beating up Karine Jean-Pierre, metaphorically speaking, of course, about this, saying, hey, these elections are like 3 weeks away, and we've got some pretty catastrophic news inbound, including inflation and economic catastrophe written all over the place. And Karine is going to walk us through why things like hearing aids are good, why more spending is actually good for inflation, and why we can expect some really nice improvements next year or so. So we've got some serious, we've got 3 clips. Zach Nichols over on Local says, three clips from her. Oh gosh, I know we got 3 of them. There are actually 4 of them. They're good because she's just getting hammered on this inflation stuff. And then there's this clip of Joe Biden eating ice cream, and he's doing that weird lip thing that he does when he's, I don't know what I'm not a doctor, so speak to your doctor about this. But when you start kind of yum thing, that sound even. He kind of does that as he's answering questions, shoving his face with ice cream. So we kind of have a little bit of a let them eat cake moment or whatever. We're going to check in with Kari Lake and Katie Hobbs. Now, the Biden people say that hearing aids are going to help inflation. Katie Hobbs says more housing is going to help inflation. It's all housing. We've got a clip from Kari Lake, who is like, I don't know, about a million times better of a candidate, like a million X better than Katie Hobbs. And she says that if she wins, when she wins, she will go ahead and accept the results of the election. We have 2 letters from Jim Jordan. He was just on a typewriter over the weekend. He's just like firing off letters. One went out over to the Treasury Department. He said, "Why are you spending so much money? I want answers." And the other one went over to, I believe, the FBI or the DOJ or somebody. He's asking about Tim Thibault. Remember that guy? The ex-special agent from the FBI who apparently covered up a bunch of stuff with Hunter Biden. So we'll go through all of that. We've got a fun clip from Marjorie-Taylor Green. She got into it with the media a little bit. They said, "Why are you such a controversial racist person?" And she said, "You have any examples?" And they said, "No." She said, "Well, that's what I thought, idiots." So we'll listen to her and some more. And so as you can see, we have got some serious business to attend to, some whoppers of segments today, including some serious heavy lifting. And if you want to be a part of the show, my friends, the best place to do that is over at watchingthewatchers.locals.com. Of course, that is down here at this web address, and you can see we've got an amazing group of people chatting away over there. Shout outs to Paul Mino, Suzanne H is here, Uncle Shane is also over there, along with John McGarvey. Hey, Henry Dixon's over on Locals, and I see Henry Dixon's over on the YouTube chat over there, modding away, along with Ronnie Cole, K Bean playing hookies over there, along with X Factor, Shane Souza, Vashna's in the house, Potato Head. We have Noy Shoemaker. And I think we accidentally banned Hippy Dippy Cali Girl also. So I think there was a request for that as well. So shout out to K Bean and others in the chat. But we have an awesome community over at watchingthewatchers.locals.com. JC the Music Man's over there. Henry Dixon's there. Souson Academy is over there. Awesome. Dana36G. Shout out. All right. And Betrayed by Corrupt Scumbags is over on Locals as well, on YouTube. Along with Michael Cleffy. I think that was the Hippy Dippy. Yeah. So I think we're clear. Anyways, also, I'm a lawyer, by the way, over at the R&R Law Group, which is an amazing law firm in Scottsdale, Arizona, where we help good people charged with crimes. 480-787-0394. We have an amazing team over there. And, we're just passionate about the work we do. So if there's any opportunity for us to help anybody who's been charged with the crime, we offer free case evaluations. You can go to rrlawaz.com. And we have a team standing by, ready to help. All right. And so without any further ado, my friends, let's get this queued up and just get right into the materials for the day. Now that we got all of that set up, because we've got some heavy lifting to get into on the program. And so let's do it. Trump prosecutors file an appeal, but this time it's for the whole shebang. They want the maximum. They want to get it all. We already know that the United States Supreme Court came out and they rejected Donald Trump's application. Donald Trump said, "Hey, can you guys step in here? We're trying to appoint a special master to sort of referee this whole document problem that we've got. The FBI raided my house. They took a bunch of materials. I say that they're all privileged, protected. They're declassified. I've got all sorts of force fields legally that I can put around these documents. But the FBI came in and they took all of it. Even though some of that's protected, I think that we should have now a referee called a special master appointed to come and look over this stuff because nobody trusts the DOJ or the FBI." Well, Donald Trump made that argument to the district court. Remember, Judge Aileen Cannon said, "Perfect, I agree with you. The DOJ has screwed some stuff up, and we do think that they need to be overseen." They appealed that to the 11th Circuit, and then Trump appealed that to the Supreme Court. At the Supreme Court, they said what the 11th Circuit did at that first level was perfectly okay. And what that means now is the prosecutors really want to accelerate that. Since they won a little bit, they want to win a lot more. Let's take a look at what the Supreme Court gave us first. Here is the order in the pending case. You see it is Donald Trump versus the United States of America. And we talked about this previously. Very blank order, not much on here. Came out Thursday, October 13th, one page. That's it. The application to vacate the stay that was entered by the 11th Circuit presented to Judge Clarence Thomas is denied, meaning Trump's request to undo what the 11th Circuit did is denied. Sorry. Supreme Court said, sorry, we're not going to hear it. So that order went over to the 11th Circuit, and this is what their docket looks like. We just saw that the Supreme Court order came out on the 13th. And look, the 11th Circuit docket, which is very similar, says that they received it. Boom. On October 13th, right here, Supreme Court order dated 10/13 says what we just read, that it was denied. Well, guess what happened the next day, October 14th? The appellant's brief, that means the United States government, the entity who is trying to get the special master thrown out. Boom, next day they got their full appeal in. And there's also 4 copies of the brief, along with 3 volumes of appendices. I didn't even pull the appendices out, okay, because like 600 pages of materials. I was like, oh my gosh, what is all this garbage? So it's just a bunch of paperwork that they attached on the back of it, and you can see it all there. Now, it is a big, hefty document, and we are going to go through it, but recall, this is the gentleman that we're talking about. Raymond Dearie is the special master that Judge Aileen Cannon appointed to oversee this entire case, and he was going to only review, well, originally, she wanted him to review everything. But the government said, wait a minute, not those 100 classified documents. They really did not want him to see those materials. And the 11th Circuit and the Supreme Court have both refused to do anything differently. And they've decided that Raymond Dearie is not entitled to those 100 documents. They've sort of gone with the status quo that the government says exists. So now it comes back down from the Supreme Court, back down to the 11th Circuit. The government has already won some of this, and now they want the entire pie. So let's take a look at the brief. 67-page document filed in the 11th Circuit Court of Appeals, Donald Trump versus the United States of America. But this is not Trump's motion. This is a brief of the United States. The prosecutors are submitting this on appeal from the lower level district court, which is where Judge Aileen Cannon appointed the special master Raymond Dearie. Government did not want that special master appointed at all. And that's why they are now appealing the full order. Not just those 2 little bits that we talked about previously. The original order from Judge Cannon said that Raymond Dearie could do 4 things. The 11th Circuit reversed 2 of those. Now the government's back to get the other 2. They want the entire order thrown out. They don't want a referee at all. Prosecutors right. They have additional disclosures. Same parties that we've seen previously, all notified that this appeal is pending. They have a statement about oral arguments. They say, the government respectfully submits that oral argument would assist the court. Saying, Judge, before you issue a ruling on any of this stuff, Judge is, since we're at the Court of Appeals, they say, we are sort of recommending that we have a debate about this. Bring us in there so we can argue about it. Sometimes they don't do that. In its October 5th, 2022 order granting the government's motion to expedite this appeal, the court indicated that the appeal will be assigned to a special merits panel, which will then decide when and how to hear oral argument. So this case is so unusual, it's breaking all sorts of precedent all over the place. And now even the 11th Circuit was saying, well, we're not really sure exactly what the structure is going to be, but this is what our intent is. And they detailed that for us. Prosecutors continue. As you can see, they detail a little bit of the table of contents for us. It is a big document. We are not going to read through all 60-something pages, but that's good news. We can skip through a lot of this stuff. Certificate of compliance can go away. We're going to fast forward through a lot of the heavy lifting. You can see a lot of this is legalese, talking about U.S. versus Nixon and so on. We've got different factors that usually is just filled with a bunch of legalese, but we can see some structure. You see that their prosecutors are arguing that Judge Cannon erred, meaning she made a mistake by saying that she has the ability to craft a remedy. This is equitable jurisdiction. They're saying she didn't have the ability to do any of this stuff, right? She didn't have the power in the first place to even appoint a special master or to stop an injunction from happening. They also say the district court stopped or failed by stopping the government from using its own records. And you can see it's really 3 main arguments, which we'll take a look at. They also have for us a table of authorities, which as usual is just a bunch of cases and statutes we'll see. And we'll fast forward through all of those as well. Here come the statutes and the authorities, the federal rules. Now we get to the good stuff, which is where we get to the introduction. Government prosecutors write. They say, Judge, at the 11th Circuit, we are asking you to throw out the special master entirely. Why? This appeal stems from an unprecedented order, writes the government, by Judge Aileen Cannon at the district court that restricts the investigation from our branch at the executive. We can't even review our own evidence, including our highly classified government records that were recovered in a court-authorized search. That was the warrant that was issued by Judge Reinhardt that authorized the raid of Trump's residence. The government says that before the search, Trump had represented in response to a grand jury subpoena that he returned all the records with classification markings on it. The government applied for a search warrant after developing evidence that Trump's response to the subpoena was incomplete and that efforts may have been undertaken to obstruct the investigation. Now, this obstruction charge, I think we've talked about, it may very well be something as simple as the custodian of records, in this case was Christina Bobb. She may have just signed that form, said, I gave you all the library books back. They say the library books were not all in there that you returned. You still have some overdue library books, but because you signed this promise that you return them, you're a liar now and you're obstructing our investigation. And so that's sort of all it is basically what we think that applies to. A magistrate judge, Judge Reinhardt, who took that warrant through a WhatsApp phone call and who then signed a warrant without really any particularity at all, something that was so broad that said that they could go get every stinking thing they wanted. They could go get the box. If the box had something that was responsive to the search, then they could just get the box above it, to the left of it, to the below it, in front of it, back, all dimensions. You found a middle desk drawer, you get the middle desk drawer and the whole desk. The warrant was so broad. But the prosecutors tell us that a judge found probable cause, the same judge who recused himself from Trump versus Clinton, that he believed that a search of the plaintiff's premises would uncover evidence of crimes, including unauthorized retention of national defense information and obstruction of justice. The government executed its search in accordance with the filter procedures that were approved by the judge to ensure that the materials would be protected. Because there could be a lot of stuff that has, I don't know, attorney-client privilege in it, executive privilege in it, work product material in it. Yeah. The search recovered, among other evidence, roughly 100 documents with classification markings on it. They say the stuff that is extremely restricted. Got it. Now, 2 weeks later, Trump initiated this action, this lawsuit, which was the ultimate lawsuit that appointed the special master. And he requested that this person, this referee, come in and review claims of attorney-client privilege and executive privilege, as well as an injunction stopping the government from reviewing and using these seized materials, as well as returning the property that's not theirs. Trump said, we don't trust your DOJ. The DOJ was leaking all over the place. They were sending this material to the Washington Post. We were reading the stories left and right. And the judge said, yeah, we do need to have somebody in here coming here and monitoring this stuff. District courts, writes the government, meaning this is Judge Cannon, the same judge who appointed the special master, they say that she has no general equitable authority to superintend federal investigations. In other words, the judge can't step over the DOJ. Instead, she challenges the government's use of the evidence that was recovered in the search and saying that they could challenge it if and when charges are filed. Right? So the DOJ, they are so corrupt that they are saying that Trump can only challenge this once charges are actually filed. But charges have not been filed, and so therefore his hands are completely tied. And he just needs to sit there and take it, in other words, while they take unprecedented action of prosecuting their literal political nemesis. He should just sit there and take it because the precedent deems such. Here, they say the district court granted Trump's extraordinary relief, stopping the use of the materials, including the classified materials, and said all of this was delayed until the special master could review it. The court, writes the government, has already granted the government's motion to stay that order, and the court should now reverse the order in its entirety for multiple different reasons. So the sentence here says that they reversed already the prohibition on using the documents for criminal proceedings, as well as the transfer of the 100 documents to the special master. Both of those things have already been done. The 11th Circuit says, yep, government, you win on those. Now they're back. They say reverse it entirely. We don't even want the special master to look at anything. Not only the 100 classified documents that we talked about were in that bucket that were really concerning for the government. They don't want him to look at any other materials at all. Nothing. There was 11,000 total documents. 100 of them were problematic. Special Master not getting 100. Now, Special Master's not even getting the 10,900 other documents. Prosecutors argue. They say, Judge Cannon, she made a mistake. She doesn't have jurisdiction to even entertain Trump's arguments in the first place. They say her type of jurisdiction, called equitable jurisdiction, over an ongoing criminal case is reserved for exceptional circumstances. Sort of feels like that might apply here. You know, the rating of the former president might be exceptional. I don't know. But they say here, Trump failed to meet this court's established standards for exercising that. They say the district court acknowledged that there is no showing that the government acted, quote, in callous disregard of plaintiffs' rights. Is it being prosecuted by your political enemy something that is a disregard of your rights? I think that might be. As a panel of this court rightly determined, that by itself is reason enough to conclude that the district court abused its discretion and they reversed it, right? So the government is doing what they should be doing. If they want to win, they're taking the 11th Circuit's own arguments and they're wrapping them right back into another appeal to expand the scope of the ruling. The Court of Appeals already came back and they said, yeah, you're kind of right on 2 of the 4 things. And so they're saying, I know, we told you. We're going to be right on the other 4, on the other 2 for the full 4. And they're taking up the arguments from the other order that we read last week. Prosecutors say the court, therefore, should vacate Judge Aileen Cannon's order and dismiss Trump's civil action. Ooh. So it's even more than that. It's, we don't want a special master. Should have never been appointed. And if the special master is not appointed on this thing, there's really no basis at all for this entire claim, is there? That means Judge Cannon is kind of not needed anymore because she sort of is there to appoint the special master. Trump doesn't have any arguments to even fight the special master. Judge has no jurisdiction to do anything. If judge doesn't have any jurisdiction to do anything, well, judge, you got to dismiss the entire claim. And guess what that means? The entire case goes away. And the entirety of this goes right back into the purview of the DOJ, right under their disgusting little mattress where they shove everything and they do everything under the dark of night. They're just going to sit there and they're just going to prosecute Trump. And they're going to, if they come across anything that's privileged, they'll let his attorneys know. Anything that's executively privileged or work product doctrine or anything that may be declassified or anything, no special master, no Judge Cannon, no jurisdiction over any of the investigation or the inquiry. So they just get to do whatever they want. Meanwhile, Trump and his defense attorneys, they have to just sit there on their hands. They only get to now contest any of this stuff if charges are properly filed. The DOJ is going big. They want it all. Prosecutors continue. They say, even if the lower level district court, Judge Cannon, properly exercised jurisdiction, even if you find that she did, they say that she still erred. She made a big mistake in ordering a special master review for these various claims of executive and attorney-client privilege. And she also screwed up by saying that we couldn't even use those records in the meantime. They say Trump has no basis at all to even assert those claims over the documents. They reference the Nixon case. They say even if he could, in some circumstances, assert that privilege, that is a qualified privilege that can be overcome where the outgoing administration or where there is evidence that is needed for criminal proceedings. So they're setting up a bunch of contingencies here. You see, it's sort of if this, then that, and if this, then that. Here, if the district court exercised, first of all, they're saying, Judge, the court had no right to do what they did. They had no authority at all. But if you say they did, here's why that decision was problematic. And if you think that decision was good, this is why the follow-up consequence was bad, right? It's sort of 3 different conditionals. And they're saying that this merits a dismissal on all 3. They say, and although that conclusion applies to all of the seized records, they say, It's especially true to the classified records because they are indeed the very objects of the government's ongoing criminal investigation. Now, our response to all of this has been that this is the subject of the litigation. They're saying that these documents that have classification markings on it are just theirs. You just presume they're theirs. Literally, their argument is if it has a classification marking on it, if it's a sticker, a folder, it's just ours. The presumption is ours, and that's the end of the story. Therefore, Special Master doesn't get it. Because it's our property, Trump doesn't even have legally a possessory claim to it because they say it's theirs. Now, Trump is saying that has not been demonstrated. You are presuming the possessory interest that those are your documents. You have not demonstrated that. Trump is saying, well, they might have been declassified, or they might have attorney work product, overreach, overlap that makes those documents within the purview of something that needs to be higher, more protected, and shouldn't go under the wing of the DOJ. But they keep jumping over this, right? It's just the presumption, and the Supreme Court's not inclined to weigh in on it. Prosecutors continue, they tell us, Trump also hasn't asserted a claim of personal attorney-client privilege that would justify the lower court's order. They say he has no plausible claim of a privilege with respect to the records that have classification markings on it or any other government documents related to his official duties, and neither Trump nor Judge Cannon demonstrated why the filter procedures here were insufficient to protect any of the claims of privilege. And I disagree with that. I mean, I think Judge Cannon did. I think she pointed out 2 or 3 different areas where she said that this was problematic. The government continues. They say the court, the 11th Circuit, should therefore reverse the district court's injunction and end the special master's review. Judge Dearie, they say he's got to go. And they give us more. Of course, they tell us why this court has jurisdiction. The 11th Circuit, they say the appeal was filed timely. And they break out the several issues that are the most pertinent. They tell us, first, one of the big issues is whether Judge Cannon even has jurisdiction over Trump and his claim, number one. Number two, whether the lower level court screwed up, whether they made an error by preventing the government from using these materials for a criminal investigation. And number three, they want the 11th Circuit to ask or to determine whether the special master should really be appointed or applicable at all, and whether or not they can have those 100 classified documents. They say Trump has no plausible claims of executive privilege or anything else to shield those materials. So they give us some factual background, and let's go through some of this quickly. Now, I know we're very familiar with all of this. We've read through several motions that have a lot of this in it, but we're always interested if there's anything else that sort of pops out from this stuff. Because we're building upon this, right? They say, Trump ended his term in office in January 2021. Over the next year, NARA tried to get control of materials. The Presidential Records Act says that when a president leaves, they're in control. In response to that, Trump eventually provided NARA with 15 boxes January 2022. It included some material that was marked top secret. NARA referred the matter to the DOJ, saying, we've got highly classified records. They're appearing to be stored improperly over at Mar-a-Lago. Trump got notification of the government. They said that they wanted more materials. NARA told Trump that if you have any objections to any of these materials, you got to send that stuff over to the FBI. They say Trump did not pursue any claim of privilege in court. And he did not suggest that any documents bearing classification markings had been declassified. Now, again, we have made the point here on this channel many times that this is not his burden to do this. Now, that's sort of an opinion, but it's legally very unlikely to be the way that the courts would find this to go, is in other words. They're saying that because this is a civil case, Trump initiated this claim. Therefore, he's got the burden. He has to make the proffer. And that's essentially what the special master said a long time ago. Said that Trump, if you want to make these things known that you tried to declassify them, you got to let us know. And Judge Cannon came back and said, hold on. How can Trump comment on things that he hasn't even seen? And so that's what ultimately got appealed. The 11th Circuit came back down and agreed with the government on this. So Trump is not going to be allowed to withhold any of these materials. And even if you made the argument that, like in a criminal case, the argument would be that this is burden shifting, that they're trying to put the burden on Trump to prove his innocence, which is accurate in this case because this is a civil claim. But the civil claim is the pretext to a criminal investigation that the government, the DOJ, is slow walking so that they don't have to disclose any of this stuff, as we talked about previously. They continue. They say, during this time, the FBI developed additional evidence that there were additional boxes at Trump's residence. A lot of materials went back and forth. Trump's lawyers and his custodian of records, this is the obstruction, from Christina Bobb. We've got Christina Bobb, who apparently was the person who signed off on that. They produced an envelope containing 37 documents bearing the classification markings. Trump's lawyers did not assert any claims of privilege nor suggest that anything had been declassified. They say to the contrary, it looked like that this was classified stuff. Trump's lawyers represented that the records came from a storage room in Mar-a-Lago, that all records removed from the White House have been placed in that storage room, and that no such records were at other places at Mar-a-Lago. They say Trump's custodian, that's Christina, produced a written certification, quote, on behalf of the office of Donald J. Trump, that, quote, a diligent search was conducted of the boxes that were moved from the White House to Florida, and that, quote, any and all responsive documents accompany this certification. Now, the DOJ is turning around and saying, well, there were additional overdue library books. You promised us that you gave us all of them. You didn't do that. Therefore, death penalty. They continue. They say the FBI then, after they signed that document, uncovered evidence that the response to the subpoena was incomplete. The classified documents likely still remained at Mar-a-Lago, and that efforts may have been taken to, obstruct the investigation. On August 5th, the government applied to Judge Reinhart in Florida via WhatsApp. They just, texting emojis. Hey, Judge, got a warrant, LOL, you available? Sure. One min, TTYS, talk to you soon. However they talk these days out there in Florida. But they are, having these text messages back and forth. They finally get the search warrant completed. The government submitted a detailed affidavit saying Trump is going to kill us all. Magistrate Judge Reinhart found probable cause, authorized, quote, here it is, all physical documents and records constituting evidence and contraband and all other items illegally in possession, along with any containers and boxes in which they're located. Look, this is where it is. They've even put it in here. Look how broad this stupid warrant is. Here, along with any containers or boxes in which the documents are located. So here it is. If you find a classification marking, if it's in a box, you get the box. You get the box, even if the box contains other documents, that's no problem, as well as any other containers or boxes, meaning separate boxes that are collectively stored or found together with the aforementioned documents or boxes. Okay, so that's like, if you walk into one closet, right, and you see one box that has one item in it, you get the whole closet. That's the warrant. It's nuts. It's crazy. All right, so it's huge. All right, so Magistrate Judge Reinhart also approved the government's proposed filter protocols for handling attorney-client materials, and that protocol wasn't all that great because stuff was leaking all over the place. Judge Cannon referenced, I believe, 2 issues that came up in this ordeal, and that's why she appointed the special master in the first place. The filter protocols provided that the agents assigned to the filter team would search Trump's office and segregate the material. If law enforcement on the investigation team found problems, they gave it over to the filter team. Filter team said that they could then communicate this over with the court and they could submit disputes to the court. If you remember, if we rewind the clock here some time ago, there was a big conversation about how this process was going to go. Special Master comes in, he referees this. And the way that, sort of in layman's terms that this would work, I mean, not even layman's terms, this is kind of exactly how it would work, is spreadsheets. Government, what'd you take? 15 boxes? Okay, you got to go through there and inventory everything. Put everything you took on a spreadsheet. All right. Send that stuff over to Trump. Trump's team says that stuff is privileged, that's executive, that is declassified, that is work product, whatever. And then the special master says, if you agree on these things, you labeled this protected, you labeled this unprotected, I'll help you battle this out. But that was under the special master. The DOJ is saying, we don't need any of that. We can handle all of this. And we know that it's okay because the first judge, the same judge who issued the warrant, they told us that our procedure that we were applying for was perfect. So Cannon shouldn't have done anything. In other words, this all should have gone back to the original warrant judge. Prosecutors continue. They say the government executed their search on August 8th. The FBI investigative team elected for the filter team to go first. They conducted an initial search of the storage room and Trump's office using the same procedures. The search recovered roughly 13,000 documents, 22,000 pages from the storage room and Trump's private office, including roughly 100 documents bearing the classification marking, some of the highest levels. In some instances, even FBI counterintelligence and DOJ attorneys required additional clearances to review the documents. Wow. Must be very catastrophic. Can't even show it to the special master. Yeah, that's how dangerous it is. Gotcha. Now, they give us some procedural history here. We've got all of the motion work that's taking place. And they tell us that on August 27th, that Trump wanted the special master appointed, and Judge Cannon basically did so. All of this was challenged, worked its way up to the United States Supreme Court, and then it made its way back down. When the government's motions were pending, the special master process commenced, and the district court extended deadlines from November 30th to December 16th. But then, all of this happened. But then, on October 4th, Trump went to the Supreme Court and he wanted to vacate this court's order, the 11th Circuit Court's order, because the 11th Circuit gave the government a victory. Trump is saying to the Supreme Court, turn the 11th Circuit around, reverse what they did. They should have never done it. They asserted that the 11th Circuit, Trump's team, lacked jurisdiction, saying that they couldn't even review a portion of the order, that the reversal should not have happened. Remember, they appealed 2 of 4 things. And Trump said they shouldn't have even looked at those things because this was an interlocutory appeal. It was an appeal of a special master order, but it wasn't something that gave them authority to do what they did. So Trump took that up to the Supreme Court and said, will you take a look at it? Unfortunately, Supreme Court denied the application, and they are making that known now to the 11th Circuit. Now, they give us some standards of review, and you can see there's going to be a lot of heavy lifting in terms of case law. We see the Ritchie factors here. We've got some case law from the U.S. Supreme Court. Cooter versus Gell, fun case. We have Vital Pharmaceuticals. And we see the summary of the arguments. And now, so let's sort of speed through this because some of this is some heavy lifting. Talking about the injunction and the special master review. They're saying both of those are unwarranted and they should be reversed. And they summarize this for us. They say, first, the court has previously concluded by granting the partial stay that they've got jurisdiction here. They say, look, Judge, 11th Circuit, you already said that you have some authority to make rulings on this. So just stay with that. Since you've already said that you've got some authority, just extend that out and keep extending that authority to the other things. You've already got it. And they say appellate jurisdiction exists. And they say third, this doctrine, you can see we're getting into collateral order doctrine and independent basis for appellate jurisdiction. It's going to get pretty dry. And so we've covered most of the heavy lifting. As we fast forward, we can see they go through some of the factors of analysis. Second main argument, the district court should not have stopped the government from using its own records. And we've gone through many of these factors already. They say Trump never showed that he had irreparable injury. They say Trump never showed that his interests were overly injured. And that Trump also never showed that he was going to be successful on the merits of his appeals. They say, in fact, he's done the opposite. They say Trump has no plausible claim. He has no privilege. He has none of these things. He's failed to establish all of these arguments. And if we continue to scroll down, you're going to see that they're sort of explaining how each one of these is supported by case law until we get down to the final conclusion, which is coming up right now. There it is. In conclusion, they say that even if this court were to conclude that neither the law nor any other portion of this should throw this case out, that national security should become the most paramount factor, and that should help the court decide. And for the following reasons, they say, in the foregoing reasons, the court should reverse the district court's order and dismiss this action. Written by government prosecutors Juan Antonio Gonzalez, Matthew Olson, Jay Bratt, and I think the actual author of this was Sophia Burrell or Julie Edelstein. Certificate of compliance, certificate of service, all submitted over to the 11th Circuit Court of Appeals. And the 11th Circuit will issue a ruling shortly after Trump and his defense team issue a response. This was what the docket looked like before Trump's team hit with their response. And so in the next days or weeks, I very likely will see sort of on 10/18 and beyond, Donald Trump and his team submit their appellate brief, and we'll see what that looks like. But of course, we will continue to follow. I hope you join us as we do. Thank you for subscribing and liking this video wherever it is you are watching it, because there's going to be a lot more on this case that we dig into. All right, my friends, now closely related, we have a little bit more heavy lifting to get into. Bannon prosecutors filed their sentencing memorandum, and they're asking for the max, exactly what you'd expect from the DOJ. They don't like Trump. They don't like anybody who likes Trump. They don't like anybody who even thinks about Trump. They want them all in jail or eliminated from the political process. Steve Bannon, of course, is a very big part of the political process. Many people say he was very helpful, if not responsible, for getting Trump elected in the first place. And as a result of the January 6th, what I say is an illegally constituted fake select committee, they have charged him with crimes, and they are now asking for 6 months in prison and $200,000 in penalties as a result of Bannon being convicted of 2 counts of contempt of court, one for not showing up when the January 6th garbage committee sent him a subpoena, the other for not producing documents when they wanted them. So today we're going to go through both materials. We've got one sentencing memo from the U.S. government submitted by the Department of Justice. Of course, Merrick Garland is the U.S. Attorney General. They're going to be asking for one side, and then Steve Bannon is asking for basically the opposite. And the way this stuff works in criminal law is we have what are called sentencing charts and sentencing guidelines. And they kind of look like big spreadsheets, to be honest with you. And you open them up and you say, okay, this charge, this criminal history, this person's mitigation and background, this type of penalty, and you add a bunch of numbers, you do a bunch of calculations, and you sort of move people around between the different cells in the law. Okay, this penalty goes this way, goes up, goes down, move, here you go. And now when we go through that process, we understand the government is typically, they want the max. They want to move you into the cell that is the biggest penalty that they can get. And the defense is going the other way. They sort of want to move you out. They want to move you to the minimum. And so when we go through sentencing, it's at the conclusion of a criminal case. A trial has already taken place. The jury has already found Steve Bannon guilty of 2 charges. Now we have to decide what the penalty is. The government's first, Bannon's second. Let's start with the government. U.S. prosecutors submit their sentencing memorandum in the case against Steve Bannon, Trump's deputy, who was convicted of 2 counts. You see, it's a 24-page sentencing memorandum, and they're asking for the maximum. Let's see what they want. The DOJ says From the moment that Steve Bannon accepted service of the January 6 Garbage Committee's subpoena, he pursued a bad faith strategy of defiance and contempt. Sounds very evil. The committee sought documents and testimony from the defendant relevant to a matter of national importance, the circumstances that led to a violent attack on the Capitol, and the disruption of the peaceful transfer of power. In response, the defendant, Bannon, flouted the committee's authority and ignored the subpoena's demands. Bannon, a private citizen, claimed that the executive privilege, which did not apply to him and would have exempted his total noncompliance if it had, it would not have exempted it, justified his actions, so he said. Then, on the eve of trial, he attempted an about-face, representing to the committee that former President Trump had waived executive privilege and freed the defendant to cooperate. But this proved to be a hollow gesture. When he realized that his 11th hour stunt would not prevent his trial, the defendant's cooperative spirit vanished. Despite the removal of the only purported barrier to his compliance, to this day, Bannon has not produced a single document to the committee, nor appeared for testimony. For his sustained bad faith contempt of Congress, the prosecutors say Bannon should be sentenced to 6 months imprisonment, the top end of the sentencing guidelines range, and fined $200,000, based on his insistence on paying the maximum fine rather than cooperate with the probation office's routine pre-sentencing financial investigation. So the prosecutors are very mad at Steve Bannon. Now, when you are convicted of a crime, if it's a felony, oftentimes you'll be somebody who goes through, I think, well, basically every time, unless it's like a designated a misdemeanor or something. But if it's a serious felony and you're convicted of a felony before sentencing, one of the things you do is you go through and you do pre-sentencing investigations. And you have somebody who drafts what's called a PSR, a pre-sentence report. And in this report, it's typically a lot of material, a lot of information, education, background, job, mitigation, drug use, substance abuse, past trauma you want to talk about, all this sorts of stuff. The point is that when you're sentenced, the prosecution, they have got one opinion on this thing. They want the maximum. They said it's at the max end of the sentencing guideline range, and they want it all. The defense wants the opposite. They want the minimum. And so the court's like, well, I don't know what to do. So they send this stuff over to sort of a neutral arbiter, so-called, which is going to be the pre-sentence division, probation division, essentially, that will sit down, do an interview, and then make an assessment. And they'll write their own independent report that goes back over to the court. So the judge then has 3 things they're looking at. They're looking at the defense attorney's recommendation, the government's recommendation, which is what we're reading now, and then they look at the PSR, which is the pre-sentence report from the neutral third party. They make a decision based on all 3. So we already know the government wants 6 months. We already know that Bannon's going to ask for 0 months. We're going to have to see what the PSR says. Bannon has refused, they say, to sit down and do the financial screening as a part of the pre-sentence investigation routine. Bannon's like, I don't need to talk to you about my finances. Well, they say, well, we don't know what you can afford to pay. And he says, I don't care what it is. I can afford it. Have you seen War Room, baby? It's popping. Money's not a problem. What do you want? $200K? No problem. We'll just pay it, right? And rather than actually, sitting down and debating a bunch of this stuff. So it makes sense. So he sort of rejects that, and he says, we'll just pay it. Now, we have a little bit of procedural background. They tell us. The government prosecutors on page 2, they write, as this court is aware, and as elaborated below, back in October of 2021, Bannon didn't show up to the committee when they subpoenaed him. 1 week later in October, he didn't show up again when they wanted his testimony. He didn't bring documents, and he didn't give them testimony. And the United States House of Representatives voted on October to hold him in contempt, right? That fake January 6th committee that is illegally constituted, even by their own rules. They said that they have to have 13 members through their own House resolution. They don't. They've got 9. They said there's supposed to be 5 Republicans. They don't have 5. They have 2. So even by their own rules, they're illegal. But they voted illegally, in my opinion, to hold him in contempt, and they referred his conduct to the U.S. DOJ out of the District of Columbia. Now, the DOJ, of course, because they are run by the Biden administration and they love to prosecute their political enemies, they said, oh, perfect. Your illegal subpoena and criminal contempt referral, we'll honor that because we're on the same team. No separation of powers, issues or anything like that. And they did that. So then they sent this over to a grand jury at the D.C. court, and they returned an indictment, 2 counts. Not showing up, contempt of court, a contempt of Congress for not providing documents, and another one for not providing testimony. Now the defendant, they say, is scheduled to be sentenced on October 21st, 1 year to the day after he was held in contempt by the House. You think these prosecutors are getting a little bit a schadenfreude out of that? A little bit of happiness that Bannon it's sort of coming full circle. A full year to the day, and we're back. Now, they give us some relevant sentencing evidence. The prosecutors say to determine the appropriate sentence, the court may consider all the evidence that's relevant to the conduct of the conviction. Anything. The court's findings of fact at sentencing are subject to different standards of review. And so they say, Judge, all of this is applicable. And they tell us a little bit more about what happened at the trial. Prosecutors say, at Bannon's trial, the reason that he willfully defaulted, that is why he deliberately did not comply with the subpoena, was not relevant. Doesn't matter. Now, at sentencing, it is. The court can and should consider why Bannon and what his motive was as part of his history and characteristics, as part of the nature of the offense. And the factual record, writes the government, is replete with proof that the defendant, Bannon, acted consistently in bad faith. And he did so with the intent of frustrating the committee's work. They say that on September 23rd, the committee issued Bannon a subpoena for his testimony. They did that because they thought that he had information that was relevant. Apparently, he gathered at the Willard Hotel to persuade members of Congress back on something January 6th. The defendant was asked to produce subpoenas by October 7th, and he didn't do that. The first deadline came October 7th. He didn't show up. His lawyer, with whom he worked closely, was responding to the committee and said that he had been apprised of everything. He was trying to figure out whether he had executive privilege, and they say that even though they were trying to determine whether they had executive privilege, that it didn't matter. They say Bannon's lawyer was just rummaging around is the word, to try to figure out an excuse, a way out. But he did that even though executive privilege could not possibly permit Bannon to not comply. They say Bannon was a private citizen. He wasn't even working in the White House. And all of this material was unrelated to his time there. So the subpoena was completely unrelated. And Mr. Costello, Bannon's lawyer, ultimately received contact information from many other lawyers and said that there's nothing he could do with his privilege. He talked to Clark, and Clark was sending him information. Clark was unsure whether the defendant had any privileged documents or any information at all. Former U.S. President Donald Trump also did not believe that Bannon possessed immunity, they say, both through its own language and other qualified language. They say Bannon was not exempt. But they say Bannon didn't even care. That didn't stop Bannon from exploiting this letter. On October 7th, he allowed the document deadline to pass, and he didn't comply at all. He failed to produce a single document. And by that time, Bannon had taken no steps to respond to anything. Costello didn't know anything. Later that day, Costello sent a letter saying that he's not complying. The next day, on October 8th, the committee rejected those claims. And they pointed out that Bannon cannot reject this and invoke executive privilege. But Bannon said, I stand with Trump and the Constitution. Bannon and his lawyer did not respond to the committee's rejection. In fact, the next contact was not until October 12th. A committee staffer reached out by phone to Bannon's lawyer to arrange for logistics. But Bannon's lawyer indicated on the phone, now he says, nope, Bannon's not showing up. The committee staffer followed up, sent 2 additional emails to Mr. Costello. Bannon's lawyer said, Bannon is not appearing for deposition. He's not coming. Stop calling. Unbeknownst to the committee, while Mr. Costello was continuing to claim on defendant's behalf that the committee that executive privilege was legitimate, Mr. Costello sent a text message to another person saying that he didn't invoke those privileges. So there's a big conversation between the lawyers, Clark and Costello. Bannon didn't show up for his deposition. No surprise there. We talked about that when that happened. And they're talking about the letters that went back and forth. All right. The day after Bannon failed to appear, the committee sent a letter to Costello that he defaulted. And we've talked about all of this. Okay, we went through this whole history. But now we get to another section. They say, Bannon also should be penalized. They want 6 months prison for his attempt to enlist Congress to pressure the Department of Justice to dismiss the case. He acted in bad faith. They say that Bannon, in July 2022, right before his trial was to begin, and after months consuming time and resources, they say that Bannon attempted to leverage the information that he had withheld to engineer a dismissal of his prosecution. He said that he tried to do a quid pro quo, they said, and this speaks volumes about his bad faith, so-called. Trial was scheduled for July 18th, and in the weeks leading up to it, he filed a bunch of motions. But as trial came upon and hit, they ultimately changed course. And we covered this whole trial. On July 13th, the day before the final trial pre-conference, the final pre-trial conference, the defendant renewed his motion to continue the trial, last-ditch effort, and then said, I actually would cooperate because Trump reversed the executive privilege claims. They say that Bannon deserves a high penalty because he's constantly made public attacks on the committee and the criminal justice system. Oh, great. The prosecutors tell us throughout the pendency of this case, Bannon exploited his notoriety through courthouse press conferences and his War Room podcast to display to the public the source of his bad faith refusal to comply with the subpoena. They say a total disregard for the government process and the law. Through his public platforms, Bannon used hyperbolic and sometimes violent rhetoric to disparage the committee's investigation, personally attack the committee members, and ridicule the criminal justice system. Bannon's statements prove that his contempt was not aimed at protecting his privilege or the Constitution. Rather, it was aimed at undermining the committee's efforts to investigate what they call a historic attack on the government. Oh, gosh. The defendant, Bannon, launched attacks on the committee and the criminal justice process right after his arraignment. He gathered outside the press hall and he gave a 5-minute statement. He ridiculed through his counsel the case as a, quote, scam from the beginning. Said that this is going to be, quote, the misdemeanor for hell for Merrick Garland, Nancy Pelosi, and Joe Biden. And he warned that, quote, we're going to go on the offense on this and stand by. When a media member asked Bannon what he meant by his statement about going on offense, he said, stand by. Bannon answered that question in the months that followed. Rather, they say, rather than respect the criminal justice process and participate meaningfully and seriously in the courtroom defense of his case, they say that Bannon, for, quote, going on offense meant resorting to name-calling, and mimicry, and menacing rhetoric, aimed at the committee's membership. Yeah, he was calling crying Adam Kinzinger a big fat crybaby, and slippery Jamie Raskin a little bit too greasy for anybody. For example, they say that Bannon on June 15th, after a motions hearing, the defendant exited the courthouse and he announced that he looked forward to having Nancy Pelosi, Lil Jamie Raskin, and Shifty Schiff in here at trial answering questions. and they give you a actual link over to a Political article for you in case you really want to look that up. Bannon also, shortly before trial, on the July 12th episode of his podcast, the defendant Bannon urged listeners to, quote, pray for our enemies because, quote, we're going medieval on these people. We're going to savage our enemies. Episode 1996 War Room Pandemic, July 12th, 2022. Available at warroom.org. Well, they linked to it. That's nice. Support your local War Room podcast. During the trial, on July 19th, Bannon gave another courthouse press conference in which he accused the committee chairman, Fishing of Benny Thompson, of, quote, hiding behind these phony privileges, ridiculed him as gutless and, quote, not man enough to appear in court, fact check true, and mocked him as a total absolute disgrace. True. The defendant also teased Adam Schiff as Shifty Schiff. They don't like these names, do they? And another member of Congress, Representative Eric Swalwell, as Fang Fang Swalwell. Isn't that his name? I thought that he changed his name after he got married to Fang Fang, the Chinese spy with whom he made Bang Bang. Remember? Yeah. I think that's his official name. I don't know what they're so upset about that one for. He went on to say that, quote, this show trial they're running is a disgrace, quote. All of that's available on YouTube, apparently. Also, during trial, writes the prosecutors, on July 20th, the defendant emerged from the courthouse and he derided the committee's work as, quote, a show trial, which it is. It is illegal. They had a House resolution. 13 members was what the House resolution said. Their own rules. Doesn't have 13. He came out and said it is a show trial because it is. And he said he's likening it to, quote, the Moscow show trial of the 1930s. Very astute observation. And days after the jury found him guilty, on July 25th, the defendant proclaimed that he was going to, quote, kill this administration in the crib. Ooh. K word. And that if the Department of Justice did not like it, it could suck on it. We're destroying this illegitimate regime. See this article from Newsweek that says Steve Bannon sends suck on it message to Pelosi, Thompson, and the DOJ. Look, I don't know what Steve Bannon's going to get. Okay. I hope he does not get 6 months in prison, but these prosecutors are very mad. Okay. They are like, he is really, really agitating them with this. Steve Bannon, in a sentencing memo, got government prosecutors to say, Steve Bannon says suck on it message to Pelosi, Thompson, and the DOJ. The government prosecutors are saying, Judge, you should punish him because Steve Bannon told us to suck on it. And we're offended that he could be so vulgar to us. So give him the penalty of the century. And they're calling us names. I mean, they, shifty and slippery and all these things. And this isn't even Bannon's motion. This is the government's own motion, right? You can tell they're very upset about this. Now, they tell us that the government accessed the War Room website, but this episode would not play. Technical problems. It can be accessed, though, on Apple and other providers. And they say, Judge, if you want it, the court, we can get you a recording if you want. If you want to hear him say he told us to suck on it, then I guess we'll pull it for you if you want it. Now, during the pre-sentence investigation, the following happened. After Bannon was found guilty by those jurors, the probation office initiated its routine pre-sentence investigation in preparation for the sentencing hearing. And for any federal defendant convicted of a federal offense and facing sentencing, they typically do a personal interview, which we talked about, as well as an assessment of their financial condition so that they can be penalized appropriately. But Bannon, he cooperated only insofar it was as convenient for his interests. He wasn't even really cooperating with them at all. He freely answered questions about his family, about his personal life, his personal background, and health. But Bannon refused to disclose his financial records, instead insisting that he is willing and able to pay any fine imposed, including the maximum fine on each count of conviction. You're not rummaging through my finances. Just tell me what the max is and I'll pay it. The probation office and their investigation of the defendant's financial condition was therefore curtailed, and they had to look at other public sources. Now, they have here the allocution that they are recommending. This is sort of the final statement of the guilt. They're saying, Judge, this is what you should accept as the guilt, the final sort of factual basis of somebody's guilt. And they detail that for us here. They say that Bannon, guilty of contempt of Congress, was taken in bad faith. He remains in default. Even after he was convicted, they still haven't gotten any documents from him, not produced a single thing or answered a single question. And he probably won't soon after the balance of power changes and the committees evaporated. Nor has he endeavored to do so. And it was only offered as part of a quid pro quo, meaning Bannon would testify if they dropped the charges. The mandatory minimum sentence, they write, of 1 month is insufficient. Mandatory minimum of 1 month is insufficient. The court should instead oppose a 6-month prison sentence, the top end of the sentencing range, and fine the defendant $200,000 based on his demand to pay the maximum fine rather than participate in the financial investigation. They give us some details on the statutory penalty. They tell us, Judge, the first step, of course, is to look at the law and see what the law says. And so you must at least give him at least 1 month in prison, and the maximum fine for each count is $100,000. And they also give us some structure on following the sentencing guidelines. They refer us, as always, over to the law. This is how it works. Look here, look there. Under this statute, they say conviction in this case, the advisory sentencing range for Steve Bannon is 1 to 6 months. Now, Bannon and his lawyers, they say, well, they think that a different section should apply. Oh, section 2J1.5. They say that's the one that is really applicable. But they say, no, Judge. We're going to look at Bannon's in a minute. But they say, Judge, no, that's not the right section. That fails to address a material witness, and it should not be applied in this case. They say Bannon is using that guideline incorrectly, and he does not explain any of his justifications for refusing. They say that the attack on the Capitol resulted in numerous felony charges for hundreds of individuals. Yeah, most of which were just nonviolent criminal trespass charges that you would see, after any concert or even in Old Town, Scottsdale, Arizona. Trespass all the time, very common. Here it is. They say that makes it not analogous to a misdemeanor matter. I disagree. I think it's very analogous to a misdemeanor. In fact, many people have been prosecuted and pled guilty to misdemeanors. But to the extent that this court analogizes Bannon's refusal to appear, they say it's most analogous to a felony prosecution and not a misdemeanor. They want it to have the mandatory minimums, and the defense wants it to be labeled a misdemeanor so that it doesn't have those mandatory minimums. If it's a felony, if it's interpreted under one rule, it's going to have a minimum of 30 days in jail. If it's interpreted under the defense's interpretation, it's going to have no jail. They're saying it's more closely aligned to a felony, which means it should have the prison versus not. They say the court should reject Bannon's dubious assertion that he's entitled to credit for acceptance of responsibility. They say he hasn't accepted responsibility at all. Here are the rules on what it looks like for somebody to accept responsibility. And they say that he has not done that. Why? Sustained bad faith. Not once since he was served by the committee for these documents has Bannon still to this day done anything, not produced a single document, not even preconditioned on making a spectacle on offering anything. They say that Costello, his lawyer, informed them that Bannon has not had a change of heart. He still refuses. And they call that bad faith continuing to this day, saying he's expressed no remorse for his conduct and he continues to attack others at every turn. Therefore, the court should reject any credit for his accepting of responsibility and designate this a level 6 offense. Again, spreadsheet, charts, we're just moving around the chart. Now, they give us some different sentencing factors. They tell us that the nature and the circumstances and the seriousness of the offense warrant maximum penalties. They write that the nature of these offenses justify a top-end penalty because a person could have shown no greater contempt than Bannon did. There's a maximum level of reprehensive conduct that exists, and Bannon's at the top. They say that it would seem that no person violating this section could be at the top of this if Bannon is not. If Bannon doesn't get the max, well, nobody can get the max because this is the worst type of behavior that we've ever seen. From time to time, he was subpoenaed. And from the time that he got that, defendant has shown his true reasons for total noncompliance with the rule of law. And he's attacking our country's peaceful transfer of power. Not once through this episode has he tried to do anything differently, and he has a total disregard for the committee's lawful authority. I completely disagree with this, and I still have not heard a good argument why I'm wrong. Behind bad faith assertions that he says, they're saying the committee is legally constituted and has lawful authority. I say no. We'll see what his defense attorneys say. But they tell us that Mr. Costello disclosed to the government that he is not showing up in front of the committee. They talk about Bannon specifically. They say, Bannon, he's got some interesting history and characteristics. They say that he defaulted on the committee subpoena, but that's just one part of a long pattern. He has a disdain and contempt for the rule of law and government. Throughout this prosecution, the prosecutors tell us that Bannon has leveraged his media platform to mock members of the committee through offensive name-calling, deride the committee's investigation through rhetoric that risks inspiring violence, and ridiculing the criminal justice system through hyperbole. They say that Bannon is entitled to his views and to express them as hard as he wants. There's nothing, though, about that is opinions. And all of those opinions should be taken into account. They say that Bannon has been engaged in a constant, vicious barrage of hyperbolic rhetoric aimed at disparaging the committee and its members, along with these proceedings, and that is evidence of bad faith. They want a big fine for him, and they say that Bannon's conduct is not an aberration. He's consistently engaged in this type of stuff. He says that they've opted for a fealty to a personal agenda, meaning Trump's, agenda, and that this sentence must address Bannon specifically. They also say that this has to happen. This has to be harsh in order to act as general deterrence, and that Bannon needs to have the same penalty as others. They conclude with the following. Prosecutors say that Bannon and the rioters who overran the Capitol on January 6th did not just attack a building. They assaulted the rule of law upon which this country was built and through which it endures. And by flouting the Select Committee's subpoena and its authority, the defendant exacerbated that assault. Bannon continued the violent attack on January 6th by ignoring the subpoena. These people are crazy. To this day, he continues to unlawfully withhold documents and testimony that stand up to this investigation, and that cannot be tolerated. Respect for the rule of law is essential to the functioning of the United States government and to preserving the freedom that's been enjoyed for more than 2 centuries. They say that Bannon's bad faith strategy of defiance and contempt deserves severe punishment, and accordingly, this court should impose a sentence of 6 months, reflecting the most severe guidelines compliant punishment available, and fine the defendant $200,000. Signed by Matthew Graves and J.P. Cooney, who is writing for the local U.S. Attorney's Office, asking for essentially the maximum penalty for Steve Bannon. And we'll see what the judge does. But before we get there, let's take a look at the actual. Let me flip this over on. Let me change the chat on there. I see some interesting stuff popping in there. All right. And so that is the sentencing memo that came out from the U.S. government. We are now going to take a look at Bannon's response. A little bit shorter, and so we can sort of fly through this one. Steve Bannon responds to the government's sentencing memorandum. He wants minimum penalties after being convicted of 2 counts of contempt of Congress. He filed a 19-page sentencing memorandum out of the D.C. Circuit Court, United States of America versus Steve Bannon. Now, this is coming from Bannon's defense lawyers, and they're asking for the minimum. The government already asked for 6 months prison, $200,000 in fines, and we'll take a look at what his lawyers say in response. Bannon's defense team, they say, the ear of a sentencing judge listens for the note of contrition. Someone was convicted. Did they learn their lesson? This case requires something more. It involves larger themes that are important to every American. Should a person be jailed when the case law which set forth the elements of the crime is outdated? Should a person be jailed for doing the exact same thing that was done by the highest law enforcement officers in the country, yet they received no punishment? Should a person who has spent a lifetime listening to experts as a naval officer, investment banker, corporate executive, and presidential advisor be jailed for relying on the advice of his lawyers? Should a person be jailed where the prosecutor declined to prosecute others who were similarly situated, with the only difference being that this person uses their voice to express strongly held political views? If the answer to any of these questions is no, then a sentence of probation is warranted. Because we believe that the answer to each of these questions is no, we respectfully ask this court to impose a sentence of probation and to stay the imposition of sentence pending appeal. Bannon's lawyers continue. They say that Mr. Bannon was a top advisor to Trump. On July 2022, a jury convicted him 2 counts of Congress, even though President Trump asserted executive privilege. Prosecutions under this law are rare. Even rarer are convictions of former top presidential advisors for contempt of Congress. In fact, this may be the first. Now, the conduct that was deemed to be offensive. On September 23rd, Bannon, through his lawyers, Robert Costello, was served with a subpoena, and they sent a letter back that said the following things. Steve Bannon is not showing up because we've got privilege. Upon receiving the letter from Trump's lawyers, Bannon's lawyer advised him that executive privilege belongs to Trump, and Bannon followed his advice. Costello advised Bannon that upon legal authority and binding opinions that came out of the Office of Legal Counsel, that came out of the DOJ, that Mr. Bannon did not have to follow this subpoena, did not have to appear, did not have to produce documents. Bannon's lawyer, Costello, further advised that the subpoena was invalid because of other reasons, like prohibitions against testimony. On October 13th, Costello spoke by phone to other lawyers, the investigative counsel for the Select Committee. Among other things, the lawyer told Mr. Costello that the committee would not allow an attorney for former President Trump to be there present. In a separate phone call, Costello told Tonali, the lawyer, that he had asked counsel for President Trump to delineate areas where they would be invoking privilege. This is all negotiations taking place back and forth between Bannon's lawyer and between the January 6th Select Committee. Costello wrote another letter. Costello sent another letter to the U.S. Attorney's Office on behalf of Bannon, but none of it mattered. They didn't care about any of that. Bannon is cooperating. They're making the point that this isn't a total flouting of the subpoena. Bannon wasn't just like, oh, a subpoena, right in the garbage. flush it down the toilet. Not at all. He had his lawyer communicating back and forth, all sorts of conversations and emails. And Bannon was following the advice of his lawyers, who were relying on the Office of Legal Counsel, authoritative opinions, long-standing DOJ policy that came out that's been in existence forever. They told Bannon, you don't have to comply. This has happened many times before. Here's how it works. And when he relied on their own documents, he got charged. On November 12, 2021, Bannon was then indicted. He voluntarily surrendered on November 15th, was released on his own recognizance the same day. Throughout the course of his case, he's complied with all the terms of his condition. Nevertheless, convicted on 2 counts. Now, Bannon's history. Mr. Bannon is 68 years old. He hosts a top-rated show that addresses current political issues. Prior to this case, he has not been convicted of a crime. When the arrest was issued in this matter, Bannon voluntarily surrendered and was released on his own recognizance. Bannon grew up in a working-class family in an integrated neighborhood of Richmond. His father worked as a telephone lineman while his mother cared for him and his siblings. It was a positive upbringing and one that motivated him to want the same chance for all life of all Americans. Bannon received his undergraduate degree from University of Virginia, went to the United States Navy, ascended to the rank of Lieutenant 03. During his time there, he was a surface warfare officer on the USS Paul F. Foster. 1980, deployed to the Persian Gulf, Operation Eagle Claw, during the Iranian hostage crisis. 1981, Bannon became a special assistant chief of naval operations at the Pentagon. While working at the Pentagon, he pursued additional studies, master's degree, national security studies from Georgetown. Honorable discharge Navy, 1983. Bannon earned an MBA from Harvard. What? Great. He subsequently worked as an investment banker, corporate executive, and a presidential advisor. Talented dude. This is a lot. They say, though in overall good health, Bannon has suffered from chronic back pain for the last 30 years. I feel you on that one, Steve. Not good. He does not drink or smoke and has no history of substance abuse or mental illness. He's like a rock star, this guy. Now, a stay pending appeal is warranted, they tell us. Mr. Bannon respectfully asserts that any sentence that is imposed by this court should be stayed. Right? They're saying that, Judge, if you are going to give him 30 days or 6 months or whatever, don't impose that now, right? Delay the imposition of the sentence pending appeal. They could sentence him and he could just go right into custody, but this is all about delaying it. They're saying, hold on a minute now. Except as provided, a judge shall order that a person who's been found guilty, who has filed an appeal, as long as they've got, clear and convincing evidence that Bannon's not going to flee or pose a danger, he's not going to run away. As long as there's okay basis for it, they say that maybe you can keep him out while it's pending. They say Bannon, he's not going to flee. Okay, he's not a danger. It's not a violent crime. He's got no other criminal convictions. He's got strong ties to the D.C. area. He's not missed a single court date. He's going to appear when ordered to do so. And even probation says that he's a pretty good guy. They say that the defendant is a good candidate for voluntary surrender. He's compliant with the conditions of his release. He's appeared for all court appearances, and he's not an apparent flight risk. So, Judge, don't put him in prison yet. If needed, they say the court can impose reasonable conditions for Bannon's release. Over the last year, Bannon has said that he's been willing and able to comply with conditions. He can pay an appeal bond, Judge, if you want him to post, a bunch of money. He'll do that. But we want him to qualify for release. They say he's not filing an appeal for delay. They think he's got really good issues. And they're saying there's a lot of law for this. Now, at every opportunity, Bannon's defense team said that the current case law is outdated. We talked about this during the trial. There was a case called Licavoli. The court, even during the trial, acknowledged that Licavoli, not a great case. They said so, as follows. The court said during the trial, I think that the D.C. Circuit Court may very well have gotten this wrong. That makes sense to me, what you just said. The problem is, I'm not writing on a clean slate here. That's what the judge said. Here's another quote They say the defendant was charged with violating this law, but that statute covered any individual who willfully makes default on certain summonses. The defendant argues he's entitled to argue at trial that he cannot have been willfully in default because he relied in good faith on his counsel. He says that the Supreme Court supports him. Now, the judge said, right, Bannon's argument was, I shouldn't have to be required to show up in the subpoena because I'm relying on my lawyer. My lawyer said legally I'm not obligated to do this. And so if Bannon doesn't show up, it's not because he intended willfully to flout the subpoena, right? He's filing, he's making this argument because he's relying on advice of counsel. So your lawyer gives you good advice that's based on DOJ guidelines and that's based on their own policies, and they still charge you with a crime. And you're sitting here as a defendant like, I was relying on what my lawyer said. And they said, well, we still think you intentionally wanted to flout the rules. But Bannon says, there's another Supreme Court case. And the judge said, that's a pretty good Supreme Court case. He said, if this were a matter of first impression, the court might be inclined to agree with Bannon and allow this evidence in. But, he says, there is binding precedent from the Court of Appeals in the D.C. Circuit that is directly on point. Okay, so we have a conflict. So Bannon is saying, we're going to appeal that. We're going to take it up to the Supreme Court. Bannon should have been allowed to present evidence in his trial that he was relying on the advice of his lawyer. That was a great defense. But the Court of Appeals in this circuit has bad case law on it, whereas the Supreme Court and a different circuit have different case law, and it hasn't been settled yet. The judge said, hey, if it was settled, things might have gone differently. Bannon's defense continues. They say, actually, this is from the judge. The judge also said during the trial that the defendant, Bannon, notes that in the 6 decades since that Licavoli case, the Supreme Court has provided clarity on the meaning of willfully in statutes. Clarity that favors Bannon. That very well may be true, but none of the precedent dealt with the charge under this law. Licavoli did. Thus, while the precedent might furnish the defendant with arguments to the Court of Appeals on why Licavoli should be overruled, this court, the district level court that convicted Bannon, had no power to disregard the valid and on-point holding. So the lower level judge was saying, I like literally my hands are tied on this issue. I can't let you use this evidence, but you might have some basis on appeal. And they're saying, perfect, we're going to appeal it. The district court judge also said, I noted in my prior decisions that I have serious questions as to whether Licavoli correctly interpreted the mens rea requirement of willfully, right? The mental state. If you're going to be convicted of a crime, you typically need 2 things. You need a guilty mind and a guilty act. You got to do something illegally, and you got to do it intentionally or recklessly or negligently. You have to have something on in your mind going on. Bannon, how did he have any intent to violate the law if his lawyer said, don't do this thing? He couldn't. That's his whole argument. But the judge said, you can't present evidence of that because there's another bad case called Licavoli. But the judge, throughout the entirety of the trial, was saying, also, it's pretty bad. Now, the defense continues. They say, because contempt of Congress prosecutions are so rare, the D.C. Circuit has not had occasion to address the viability of Licavoli, given the evolution of criminal law on the mens rea element, right? We haven't seen any of these cases because nobody ever gets prosecuted for it, ever. So we haven't had an opportunity to explore how this works. This case presents a unique chance to update the law. The current state of the law burdens subpoenaed congressional witnesses with navigating complex legal principles, like executive privilege, that are the argot of lawyers, not laymen. The inherent risks of this approach cannot be understated. Executive privilege is critical to the proper functioning of the executive branch because it protects the confidentiality of decision-making, and it ensures that presidential advisors can act with candid advice while preserving the autonomy and the independence of the branch. The facts below of this case show that Bannon's conduct was based on his good faith reliance on his lawyer's advice. Every pre-indictment communication in this case was between lawyers. The Select Committee sought service of the subpoena, not on Mr. Bannon, but via his lawyer, Mr. Costello. Communications that followed between the committee and Bannon were also all conducted through lawyers. Based upon clear authority, Costello provided legal advice to Bannon. Costello provided legal justifications for Bannon to do so, and they even received responses back from the own Select Committee lawyers. Costello provided advice to Bannon. Mr. Bannon acted on that advice. Costello's advice, followed by Bannon, included the following things. One, that the committee subpoena was invalid based on long-standing U.S. Department of Justice authority because the Select Committee would not allow former Trump's counsel to be present at Bannon's deposition. Couldn't protect executive privilege. They said, we've got precedent. A former White House official does not violate the law when a president invokes executive privilege. They say that Trump could not waive executive privilege since the privilege belonged to a former president. Mr. Bannon could not waive the privilege because it belonged to Trump. And they also say that because Trump asserted it, Bannon was not in a position to even determine what he could do. And they also say that they were trying to do what they've done previously and reach reasonable accommodations between the parties. But Bannon's prior experience led him to believe that these accommodations would be settling this all. For instance, in February 2018, after an accommodation was reached, Bannon testified on another committee, the House Permanent Select Committee on Intelligence. He went there and he talked to them. Also, in February 2018, after an accommodation was reached, Bannon testified pursuant to a subpoena in the Mueller investigation. And in another one, he showed in front of the Senate Intelligence Committee there as well. But a lot of people didn't get to hear most of this. But in this case, if the D.C. Court of Appeals overrules Licavoli, then Mr. Bannon qualifies for release. They tell us that Bannon also should be allowed to contest the applicable law. And they give us some facts as to why that should be appropriate. They say Bannon has never contested the facts underlying his conviction. He admits he received a congressional subpoena. He knows that. It came from the Select Committee. They wanted documents and they wanted testimony. There's no dispute. Bannon did not provide those materials. He knows it. We know it. You know it. It's not bad faith. He's not trying to hide anything. It's all part of the deal. As evidenced by pretrial motions in this case, Mr. Bannon's challenges were both legally and constitutionally based. Bannon is not trying to go out there and cause a bunch of damage unnecessarily. You have a right to legal defenses in this country. That's all Bannon was doing. For example, Bannon disputed the applicability of the law. He was a former executive official. The law says there's protections. He was using that. He's allowed to do that. He challenged the constitutionality of the government's conduct in building and prosecuting the case. He's allowed to do that. He sought relevant material and discovery from the government. Fair. And he contested the government's position about legal arguments. The legal challenges advanced by Bannon was not meritless, wasn't frivolous, wasn't aimed at anything in bad faith. It was aimed at protecting his constitutional rights. And for these reasons, the fact that Bannon chose to put the government to its burden, make them prove the case, should not preclude him from receiving a reduction to his offense. You're allowed to challenge these things. This is America. You have a right to trial. You don't get a trial penalty, a trial tax for going there and making the government present their evidence. They say that the applicable base level offense is 2J 1.5. This is a misdemeanor failure to appear. They say, Your Honor, Bannon objects to the application of 2X5 and instead wants 2J1, different penalty standards. They say that the language in the government standard makes it explicit that it should not be applied to different rules. And they say that our statute is more on point. It's more analogous, where a defendant refused to testify at a criminal trial, where it's based on good faith reliance of counsel. So they found a different sentencing provision, and they say this penalty is a little bit different. That one's like, I'm not showing up because F you guys. And this other one is, I'm not showing up because my lawyer said so. They're different. Not showing up because F you is different than I'm not showing up because of my lawyer, right? They're different. And they're saying one penalty is a little bit, one of those is worse than the other. And Bannon did the less bad one. So therefore, he should get less of a sentence. He therefore requests that the lower penalty be applied and that the base level is 4. And they continue near the end. The final argument from Bannon's defense is that a sentence of incarceration, putting Bannon in prison, would be unconstitutional because Bannon was acting lawfully. At the government's request and over an objection by the defense, they say the court instructed the jury that a conviction under contempt of Congress did not require Bannon to believe that what he was doing was wrong. The court also prohibited Bannon from presenting the jury with evidence that he relied on his lawyer's advice in determining how to respond. There was therefore no evidence presented that Bannon believed that his conduct was unlawful. Bannon thought he was just following advice of lawyer. The jury was not even allowed to consider evidence of Bannon's state of mind, and therefore Bannon objects to any sentence of incarceration under these circumstances because they didn't prove his mental state. They didn't prove his guilty mind. Imposing a sentence of incarceration without requiring proof that Bannon knew that this conduct was wrong, where the statute says that a person has to act, quote, willfully, meaning in your mental state, you got to have a willful volition. Got to do something willfully, otherwise it's an accident, isn't it? Would violate his rights under the 5th, 6th, and 8th Amendments to the Constitution. The rejection of a mens rea, which is the guilty mind requirement, that includes some consciousness of the wrongness of the conduct, has come under sustained criticism for many years, especially compelling terms where a term of incarceration is possible after a conviction. How can you put somebody in prison if they didn't even know what they were doing was wrong? Doesn't that sound like an insane justice system? Well, we do it all the time. And there's a bunch of law review articles that explain why this is a problem. Courts have made clear that willfully, in the context of a criminal statute, requires proving that Bannon knew or believed his conduct to be unlawful or wrong. Did Bannon, when he was listening to his lawyer, say, it's okay if you don't show up? Did he know that that was wrong? Was he taking advice from a criminal lawyer? Of course not. So how can you imprison somebody for doing conduct that was not knowingly wrong? For the foregoing reasons, they say that the court should not put him in prison because incarceration would violate his constitutional rights. And the last subsection E, as discussed above, they write, we respectfully request that this court stay the sentence imposed in this case. Bannon acknowledges that a judge found that a mandatory minimum sentence might be appropriate. The government acknowledged that it's also appropriate, but they also agree that a sentence of probation is available under the U.S. Code. Why? The term, quote, punishable is not mandatory directive like shall be punished. Moreover, the rule of lenity weighs in favor of finding that there is no mandatory minimum sentence under the law. To the extent that the government argues that mandatory incarceration is required, they say that's not accurate. Imposing a sentence of incarceration under the circumstances in Bannon's case would run contrary to the fundamental constitutional principles of our law, and it would violate separation of powers and interfere with the court's sentencing discretion. And Judge, if you're not going to not allow him purely probation, they say if you are going to imprison him, Mr. Bannon respectfully requests that any sentence be served on home confinement. They say Bannon qualifies for home confinement because his guidelines fall within the range of Zone A in the sentencing spreadsheet. And if that's not possible, in the alternative, the recommendation of probation is preferred. If the court does deem that a period of incarceration is warranted, Bannon requests that the court follow the probation office recommendations. In conclusion, Bannon's defense team can say the following. For the foregoing reasons, Mr. Bannon, through his counsel undersigned, respectfully requests the court impose a sentence of probation, meaning no incarceration, no prison, and stay in possession of the sentence pending the appeal. So no prison, and if you are going to impose a penalty, put it on hold until after we are able to take this up and see what the courts do, in particular on the Licavoli issue. So that is now Steve Bannon's defense team submitting their sentencing recommendation over to the prosecutors. And that means that we'll have to wait for Judge out of the D.C. Circuit Court to issue a ruling. And of course, we'll follow that. I hope you join us on that journey. As soon as that hits, we'll go through it in detail. We'll be waiting for the conviction and the sentence for Steve Bannon. Thank you for subscribing and liking this video wherever it is you are watching it. And we will see you on the next one. All right, my friends, we've got one final segment on the day. And we did some seriously heavy lifting on that one, didn't we? But now we are done with some of the legal reading. But we do need a parchment break. We're going to get into some Biden-omics and hearing aids and our recession. But cheers to you, my friends. It's a parchment break. Beautiful Monday, my friends. Cheers. Getting some hydration going so that our mouths don't turn into parchment, lest we be parched. But now we're going to talk about Joe Biden. Look at this ice cream gif. Yeah. Oh, and hey, shout out to Henry Dixon. Henry Dixon's chiming off, taking off for the night. Shout out to Henry Dixon. What's up, Lean? Says it was a dry one tonight, Rob, but great job as usual tonight. Yeah. Well, thanks, Lean. This one's, it's a little dry today. No doubt. It was a lot of legalese. We're not done yet. We got one full segment, and this is where we get into some political spice in a minute. But we're not done. We're going to get into it right now with our president and this ice cream. Oh, all right. So let's just hop right to it. Recession, 100% chance now, according to Bloomberg, and that's largely thanks to this guy eating ice cream while the rest of America burns. We're going to take a look at a lot, including a new report from Bloomberg. They've done some modeling on this. They say it's 100% certain things are not looking so good. So we'll talk about all of that. We'll take a look at some reaction. Peter Doocey asked some hard questions of the White House about inflation and about the upcoming elections and how difficult things may be for many Americans. We'll check in with a hot race out of Arizona. We'll see what Jim Jordan has to say over to the Treasury Department and about the FBI before we check in with Marjorie-Taylor Green and some of her comments during a recent debate. But first, big news impacts Americans all over, the country. And it's not looking like things are getting better. Bloomberg is reporting, see here. Bloomberg reports recession at 100% chance now. Not even a question about it. From the economics section, we see the headline says that within the year, forecast of 100% recession likelihood, big blow to Biden. Now, this is effectively certain in the next 12 months. Bloomberg economics model projects it. Comes out from the following people. The latest recession probability models by Bloomberg economists Anna Wong and Eliza Winger forecast a higher recession probability across all timeframes within the 12-month estimate of a downturn by October 2023 hitting 100%, up 65% from the comparable period in a previous era. Unwelcome news from Biden, who said repeatedly that the U.S. will avoid a recession and that any downturn would be, quote, very slight. So it doesn't sound good. Now, they tell us that the tightening financial conditions, persistent inflation, expectations of a hawkish Federal Reserve pressing ahead with rate hikes are raising the risk of contraction. The model is more certain of a recession than other forecasts. A separate Bloomberg survey of 42 economists predicts probability up now to 60%, up from 50 a month earlier. Forecasts are a sharp contrast to Biden's upbeat tone. He's out there eating ice cream. The chance of recession, according to Bloomberg, has reached 100% under the current model in the next 12 months. They say the odds of a recession hitting sooner are also up. The model forecasts the likelihood of a recession within 11 months at 73%, up 30%, and the 10-month rose to 25% from zero. Not good news from the Biden administration, and of course, that is causing some panic. It is election season, and they definitely do not like that. And so they are getting asked about this in the White House. Peter Doocey asking about inflation, saying elections are right around the corner. Everything seems like it's getting worse. Hey, Karine, you represent the White House. Are you guys doing anything meaningful to address some of this stuff?
Following up on something you said earlier, if President Biden's top domestic priority is inflation, why doesn't he have more to show for it?
So the president understands, and we've talked about this many times, that inflation is an issue, high cost. Cost is an issue for the American people. And so he's been very clear about making that his number one economic priority.
Okay.
And he has done the work. And he's done the work with congressional Democrats. When you think about the Inflation Reduction Act, which is going to lower the cost for our seniors, millions and millions of seniors across the country. When you think about that $2,000 cap on their own Medicare prescription, when you think about the thousands of dollars that our seniors pay a month, now that's going to be $2,000 a year. That is the work that congressional Democrats and Republicans
Where'd that money come from, though?
Democrats and the president has done. Republicans did not vote for that at all. And what Republicans want to do is that they want to repeal that very historic piece of legislation that is also going to lower energy costs, that is also going to help fight climate change. They want to get rid of it. So
because it was expensive, causing inflation.
We're going to make, which is how Republicans are actually going to make things worse. And Democrats want to do the opposite and make things a little easier. I just talked about the hearing aids, which is going to help 30 million Americans across the country.
Hearing aids, she says. Hearing aids are going to solve all of the issues out there. So I guess we should probably talk about the hearing aids from the White House. While many Americans are watching their bank accounts drain away day by day as groceries go up, gas prices remain high, people wonder where their money's going. Good news, hearing aids are now more available thanks to the stellar leadership of the Biden administration.
CBS News poll that was out yesterday indicated that 2/3 of voters believe that the administration is not doing all it can and could be doing more to curb inflation. What does the White House think? Does the White House think it's doing all it can to curb inflation?
What we understand is, we understand that the American people are going through a difficult time. And we have said that. You've heard the president say that. And we understand how it is tough. It is a tough time for them. That's why we're doing stuff like the hearing aid. 30 million people saving $3,000, that's a big deal. That is a big deal, and that's because of the action that the president took by signing this executive order, as you all know, a couple of months ago. That's why he's worked so hard to get those gas prices down by more than $1 a gallon from the highest points that we have seen just a couple of months ago. And he'll continue to work on that. I was just asked by your colleague about what we're going to announce. You'll hear directly from the president. That's why the Inflation Reduction Act is so critical and key, because it's going to lower energy costs and it's going to lower healthcare costs. We get it. We get it. I know you're asking me about a specific poll, a specific number from your own publication, and we get it. We understand.
They get it.
We're going to continue to do the work. It's not going to stop us. And you have seen the results. You have seen the results from this administration.
That's great news. So they hear it. They're listening. They're paying attention. And hearing aids. So you can now hear more clearly the sound of your bank account crashing to zero. You can now hear more effectively the screaming sounds of starving children all across America. Thank you to the Biden administration. Hearing aids are now readily available. That's going to help with all of our problems. And there were some pretty interesting correlations that exist. You know, the Biden administration recognizes that there are some pretty serious inflationary issues. And it seems like a lot of this stuff started happening about 18 months ago when they passed one of the most insane spending bills of all time. Let's see what the White House does with the correlation between the current state of affairs and that old action.
18 months ago, when the president took office, inflation and gas prices started rising.
Well, 18 months ago, the president signed the American Rescue Plan, more than about back in April of 2021.
Very expensive.
And that helped the American people. That helped start reopen small businesses, that helped reopen schools. That was something that was so critical to meet the moment that the American people were going through.
Okay, but now the country's a wreck. And 18 months ago, things weren't as bad. So you pass the bill. 18 months ago, we start seeing inflation, high costs, the wrecking of the country. And you're pointing back to that as a success. That's the cause. That's the reason everything is broken. Because you kept spending money that the country didn't have and didn't need. And the country was opening back up at that time. But you guys came into power and you wanted to turn this into a big surplus. Now the bill is coming due. Karine Jean-Pierre is trying to look back on the thing that caused the problem as the solution to the problem. They're having a difficult time over there. Now we have a lot of questions about this, and so did the media. Members of the media asking, now that the Inflation Reduction Act has been passed, and you guys promised this was going to fix a bunch of stuff, when can we expect the effects to come into play? When is the Inflation Reduction Act actually going to start reducing inflation?
More than on inflation. Can you give us a timeline? You've laid out eloquently what the president's been doing. Is there a timeline for when Americans can start feeling some economic pain relief?
So in regards to the Inflation Reduction Act, early next year, they will see some of the pieces of that. When you think about an energy cost, when you think about the Medicare kind of benefits from that. So we'll see some movement on that early next year. But when we talk about inflation, gas prices, that's been something that's the American people have seen for the past several months, several weeks, and as costs has been coming down. And the hearing aids that I just laid out.
There they are again.
That, once I have a clearer timeline, that Americans are going to see, that I'll share with you on all of that. But
yeah, and we'll see if those are available. I see over on Locals. Yeah, I mean, these things may not even be available. So Karine says that spending money is helping to solve the inflation problem, failing to recognize that the spending of the money may have caused the inflation problem. And if you are even remotely intelligent, you'll understand that none of this matters because you can hear now. You can get to hear all of the pain and suffering and misery that they've created around the world for a lot lower price now, thanks to the Biden administration. As the country continues to crumble all around the world, Biden gets asked a question about the economy. And of course, he mumbles his way through it. President Joe Biden with a big fat cone of ice cream, mumbling his way through an answer on the economy. While many Americans are hungry and not going out to eat ice cream and having extra sweets and leisurely activities because they're busy working, trying to save their bank accounts and their businesses, the president says the American economy is strong as he shoves his face.
Concerned about just one more economic one. Are you concerned about the strength of the dollar right now?
I'm not concerned about the strength of the dollar. I'm concerned about the rest of the world. Does that make sense?
Can you explain that?
Yes. Our economy is strong as hell. The internal. Inflation is worldwide. It's worse off everywhere else than it is in the United States. So the problem is the lack of economic growth and sound policy in other countries, not so much ours.
Their fault, not ours.
It's worldwide inflation. It's consequential.
Worldwide inflation. It's a pretty big deal. Has nothing to do with what this guy's done, with his $1.9 trillion in spending, with his additional ballooning of the government budget, with additional student loan disbursements, and the list goes on and on. Money just keeps flowing. Joe Biden keeps eating ice cream while the rest of the country burns. So the Democrats are having a tough time with the inflation narrative. They really don't want to talk too much about it. Katie Hobbs was asked about inflation, said, why? Hang on a second. Let me make sure this audio is good. Yeah, this is okay. Hang on a second. Katie Hobbs is asked about Inflation. They say Joe Biden is still in office. He's been in control for the last couple of years. The White House, along with the House of Representatives and the Senate, all controlled by the Democrats. So why is inflation so rampant and so persistent? I mean, Katie, are you guys to blame for some of this?
Real quick, inflation is near its highest level in 4 decades. You heard me ask Kari Lake about Phoenix, highest inflation in the country. Democrats control the House, the Senate, the White House. Does President Biden bear some responsibility for inflation that we're seeing that are affecting people's everyday lives?
Inflation in Arizona is being largely driven by skyrocketing housing costs. And we have to do more about housing. We need to build more, bottom line.
Got to build more houses. Yeah, that's the problem with inflation. It's not Joe Biden spending. It's not, endless war, supply chains, lockdowns, whatever it is. It's about housing. Katie Hobbs talks like she is in high school to Arizona, and she's going to solve all of this with a housing bill or building more houses or something like that. Kari Lake gets asked an interesting question about the election. Kari Lake running for Arizona governor, and of course, people asking the same question they asked Donald Trump. Hey, Kari, are you going to accept the results of the election? Are you going to, walk out of there if you lose this with your held high and just say, congratulations, Katie Hobbs, or no?
Let's look ahead and let's talk about the 2022 election. Will you accept the results of your election, Ms. Lake?
I'm running against a twice convicted racist who cost the state taxpayers $3 million because of her hatred for people of color. She paid a woman of color in her office $30,000 less than men doing the same job. Last week, we learned she held a slave auction, a mock slave auction in high school. We saw her running from a black reporter, hiding in the bathroom from him. I'm not going to lose this election because
I'm going to talk to Katie Hobbs. I'm going to talk to Katie Hobbs right after we're done.
Arizona will never elect a racist like Katie Hobbs.
That's right.
My question is, will you accept the results of your election in November?
I'm going to win the election and I will accept that result.
If you lose, will you accept that?
I'm going to win the election and I will accept that result because the people of Arizona will never support and vote for a coward like Katie Hobbs who won't show up on a debate stage. She's single-handedly destroying a 20-year tradition of gubernatorial debates because of her cowardice. So I know already no momentum behind her. The polls are in our favor, and we're going to win this election. I'm 100% confident of that. We have the ideas, common sense ideas that people want, and we're seeing Democrats pour over and vote for us right now. I've had many people reach out and say they're voting for us. So the Democrat Party is faltering. It's not the party of solutions. It's the party that has caused the problems that we're in right now.
Kari Lake, I really appreciate you coming on.
She says, I'll accept it if I win. And I'm going to win because Arizona would never elect such a racist like Katie Hobbs and somebody who is such a coward that she won't even show up for a very friendly, very peaceful debate with her opponent. What a shame. Kari Lake is hopefully going to win that one. Election is coming up very soon. We have more before we wrap it up and get to your comments and questions. And our first letter is from Jim Jordan. Representative Jim Jordan going after the Treasury Department. A lot of spending taking place in the United States government, and some House representatives have some questions about it. You can see this letter went out on October 14th over to the Secretary of the Treasury, Janet Yellen, and to the Commissioner of the IRS, over to a person named Charles Rettig, the Honorable Commissioner. Jim Jordan says, "Dear Secretary Yellen and Commissioner Rettig, on June 6, earlier this year, we requested documents and information about a rulemaking change that would unlawfully expand the eligibility for taxpayer-subsidized health insurance under Obamacare, expanding the Obamacare package. As we explained back then, the proposed rule would lead to tens of billions of dollars in new federal spending, drastically expanding the Obamacare provisions in a manner unintended by law. Despite severe consequences posed by this expansion, the Treasury Department and the IRS have refused to cooperate with congressional oversight. According to Treasury staff, your rulemaking process was ongoing, but now you're done, and so we're going to reiterate our request. On October 11th, the Treasury Department finalized your rule very recently, and regrettably, the administration adopted, quote, the affordability test as proposed. As we explained in our initial letter, this affordability test is inconsistent with the text of Obamacare that was passed by Congress. They are changing the rules when they implement it. You have big pieces of law that go into place, and then you have the rules for how the law works. They're saying that the rules are changing the scope of Obamacare. They're expanding it out in a way that was not intended by Congress. They say that this is a bad policy. It's going to result in tens of billions of dollars of new federal spending. Now that the rulemaking process is finished, the administration's stated reason for not complying with our oversight is gone. And so Jordan says accordingly, we expect that you'll promptly produce the entirety of the documents and the information that we seek and schedule the briefing that we requested back in June. And for your convenience, we've attached the letter that we sent previously. Please respond no later than November 28th and schedule a briefing with us no later than November 11th. Signed by Jim Jordan and James Comer, members of the Judiciary and the Committee on Oversight and Reform. Copied to Jerry the Nadler. So that's Jim Jordan saying, hey, you're spending a lot more money. You're doing things that are not constitutional. Congress passed Obamacare. There's rules. You're going beyond what we intended in Congress. That's illegal. We want answers. We'll see if Jim Jordan gets them. Jordan also sent another letter over to Tim Thibault's lawyers. Tim Thibault is an ex-FBI special agent, retired or was fired or resigned very recently. And this letter comes from Congress of the United States, from the House of Representatives, the Judiciary Committee, signed by Jim Jordan, Mike Johnson, Darrell Issa, all members of the House. Tim Thibault, the FBI special agent, is addressed as follows. It says, Dear Mr. Thibault, we are in receipt of your lawyer's letter dated October 7th in 2022, and you declined to appear for a transcribed interview concerning allegations of abuse and misconduct when you were there with the FBI. Your refusal to testify is very curious in light of your earlier public statement that, quote, you welcome any investigation into these matters. As we previously informed you, whistleblowers have come forward with allegations that you took certain official actions for political reasons. As we continue to investigate the politicization of the Justice Department and the FBI, your testimony remains crucial to our inquiry. Mr. Thibault, your baseless assertion that sensitive law enforcement information or pending investigations prevents your cooperation with our inquiry ignores the importance of congressional oversight, as well as the committee's past practice of examining misconduct. The Supreme Court has repeatedly explained that congressional oversight power is broad and indispensable, and that it encompasses inquiries into the administration of our existing laws. The Judiciary Committee is authorized to conduct that oversight pursuant to the rules of the House, and we've exercised that authority on several occasions. There is no rationale or legal basis for your refusal to cooperate with our inquiry for the reasons that you articulated previously. In addition, your lawyer asserts that you cannot comply with our document preservation notice because you've left federal service. The House said, we know you're not at the FBI anymore, but you better hold on to all your documents. You better not be deleting anything because we're coming for them. And he said, I can't because I don't work for the feds anymore. Notably, this assertion ignores that our notice includes both official and personnel records that may be responsive of the topics you're investigating. And to the extent that you possess any of those personnel records or copies of official records in your personal possession that may be responsive to our inquiry, we ask your attorney confirm to us that you are preserving those. But if you have no personal records, we ask that your attorney tell us that. We still request that you appear for a transcribed interview, and it remains outstanding. Your testimony is necessary for our oversight, and you can be assured that committee Republicans will continue to pursue this matter into the 110th Congress. That's the next term. We again reiterate our request that you appear promptly, and please direct your attorney to talk to us about this. Signed by Jordan, Johnson, and Darrell Issa, from the United States House of Representatives. Letter going over to Tim Thibault, who left the FBI. Republicans saying, when we're in charge, brace yourselves for impact, because they're going to be cleaning up the FBI and the DOJ. We had another debate clip, a lot of debates going on tonight, which we may check in on tomorrow. Marjorie-Taylor Green asked about controversial statements. The media, as usual, they say, why are you so divisive? And they give her no examples before she details where she stands and why she stands where she does.
All right, this is to Marjorie-Taylor Green there. You're well known for making controversial statements. Detail your process for vetting and fact-checking your statements that you make in public and post to social media.
Can you tell me what's controversial about defending the freedom of speech?
Cite your sources.
What's controversial about defending our border or saying we need to? Can you tell me? Give me an example.
No, you do this every time we have a debate where I ask a question that's obvious, and you're like, "What you mean?" You were kicked off of your committees.
What's obvious
for
about
saying
that?
Things were controversial. You've apologized for controversial statements, right? Those types of things. What is your process for fact-checking and vetting the things that you say in public?
Well, she doesn't go to your garbage news site and go to your fact checks and all your thumbs up and downs and pants on fire. None of that.
The things I say in public are the truth, and that's why they're so offensive to Democrat activists in the media just like you. And you're asking me a blanket question with no example. I stand by the things that I say. I stand by saying that we need to secure our border, that we need to protect all of our freedoms and our rights, that we need to stop the America Last Democrat communist policies that are destroying our country. I stand by the words that I say. They're just offensive to Washington, D.C. and the swamp creatures there, because the words that I speak are the same as Americans back home, the same as people in Georgia's 14th district. And the words that I speak are the truth. And you want to know something, Josh? Sometimes the truth hurts, and Washington deserves to hear it. We're over $31 trillion in debt. Our government has failed the American people, and right now, this administration has us on the verge of a nuclear war with Russia, where they care more about funding a war in Ukraine than they care about protecting Americans, helping homeless people on the streets, and securing our border and stopping fentanyl from killing young people in America.
All right, this is to
Didn't sound controversial at all to me. Sounded like a pretty reasonable statement that I think many Americans might agree with. But the media, yeah, they probably didn't like that one. You can see that debate moderator, he's squirreling around in his chair. Freedom, freedom, I hate that stuff. And so they're all freaking out over there on the other side of the table. But that, my friends, is the update. Biden's recession now very, very likely. Bloomberg says 100% certain. But good news for all of us, hearing aids are available. So go get your hearing aids, whether you need them or not. If you don't need them, just turn the volume up maximally loud so you can blast out your eardrums so you don't have to hear the catastrophic news that's going to be coming from the recession that's about to hit any minute. So that, my friends, is the update. We will, of course, continue to cover all of the political news and drama. Thank you for joining us as we do so. I appreciate you liking and subscribing to this channel while we continue to cover it, and I look forward to seeing you on the next one. All right, my friends, and so that was it for the segments on the program. Let's see what we got here today. We got some Biden economics, going to be a problem for the country. We have Bannon prosecutors and 2 sentencing memorandums that we went through, and we covered a big fat whopper brief on appeal up to the 11th Circuit. And man, there was a lot there. There was a lot to attend to. But I saw some super chats come in. And so let's make sure we attend to some of the super chats before we head on over to locals and wrap things up over there. Let's see what we've got from the YouTube super chats that just came in here. And thank you, everybody. Very generous of you today. All right. And so, of course, my screen is not loading because that's just how it goes on these types of days. When I need it to work, it just doesn't. But that's all right. We've got it here. Now, thank you to the super chats that came in from all of our friends on YouTube. We had, starting us off, Miguel Labra with no question, but thank you, Miguel, just for a nice dono. Thank you. No question on that one. Molly Dolly is here, says, a little off topic, I vote in Maricopa. I believe there are 47 judges on the ballot. Do you have a list of judges to retain? I'm hoping because you practice in Scottsdale, you may have many judges. You may know the judges. Yeah, I do. We do sort of pass a list around. No, I don't have an official list of judges, and probably not something that I would sort of want to publicize anyways, like publicly, just, you can kind of get on the bad side of some judges and stuff. I mean, it's something we talk about as lawyers, of course, but, the judges are important, of course, but our system here is bizarre. You can Google them if you see anything problematic about the judges. That's about as far as I would go, Molly. You're a good citizen for spending a lot of effort on it, but unless something stands out, most of the judges I'd say are pretty good. There's a handful, you can sort of debate about, but they're mostly pretty good. Curtis Bartle says, swear jar, I called the FBI. Well, thank you, Curtis, for the swear jar. Velcro Kitty says, these people are so power drunk. Bannon said he has talked with them. I believe Bannon did. I think they're punishing him for using executive privilege. I think they're just, I think they're punishing him because he's a Trump person. That's about it. Yeah. And they're using any mechanisms they can to accomplish that. Hope and Peace says, thanks for doing such great coverage of all of this. Well, thank you, Hope and Peace. Thanks for the support and for being here. Eddie Oliver says, hey, Rob, sorry you're in Arizona, so not likely going to make it in the coming global apocalypse. Yeah, that's probably right. He says, but I'll be fine because I'm in Texas. So, sorry, good luck. Yeah, it's too bad. It's too bad that we're going to die here, Eddie. Yeah. It's too bad we're all going to be, obliterated in Biden's recession. But hopefully you're having fun out there in Texas. Good luck to our Texas friends. Eddie says, and Rob, as you know it, I work in oil and gas in Texas, he says. And the way they tell the truth in those White House statements makes men wonder when I will get a dragon or unicorn promised to me from this administration. That's true. You might one day, Eddie. They're promising everybody everything. But yeah, Eddie's in Texas. And I've talked to Eddie about some sort of some stuff like that. Eddie's doing it. He's doing it right now. We were talking about getting off the grid and how close he is to being off the grid. So shout out to Eddie. Hopefully it's going well out there, my friend. But all right, my friends. And I think that was it from the super chats. And so we are going to leave it right there. We're going to take this back over to locals for the after party, which is where we're going to hit the comment section from the locals stream. But I want to thank everybody who was a part of the show, who sent in those amazing super chats and who kept the chat nice and lively. And if you want to join us over on our community, that's over at watchingthewatchers.locals.com. We're going to head over there right now for the after party and get through some more comments. But before we do, I am also a lawyer at the R&R Law Group. We're located in Scottsdale, Arizona. We help good people charged with crimes from all over Arizona. And so if you happen to know anybody who's in town visiting the Grand Canyon, if they're checking out Scottsdale or downtown Phoenix or a conference, convention, whatever, they get in trouble, we are the law firm to help. 480-787-0394. Any type of criminal charge, we can help. And we offer free case evaluations. We have a mission to help good people charged with crimes find safety, clarity, and hope, not only in their cases, but beyond that, in their lives. You can also find us online at rrlawaz.com and schedule those free case evaluations today. Thank you to the mods who modded down the forts for us to keep the chats nice and orderly. Shout outs to Vientikis. I saw K Bean in the house. Just Cause. Our friend Lean is over there. Playing Hooky, Ronnie Cole. I saw Zulu, Geo, Henry swung by. And thank you to our friends who keep things nice and orderly. We also have our Spotlight supporters. Big thanks go out to Chris Romero, David B3, Dr. EMB in the house, along with John over at qsimple.com. And that's it. That's what we got. That's what we got on the day. We're going over to locals for the after party. We've got some comments to attend to over there. So go on and join us if you want to see us. Otherwise, my friends, that is it for us today. I do hope to see you right back here tomorrow. Same time, same place. So that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Have a tremendous evening, my friends. I'll see you right back here tomorrow. Bye-bye.